Good morning. It's a pleasure to have with us Marshall Lerner of a noted Hollywood law firm who somehow or other was unable to snag a ticket to the events that were going on in his hometown, and he preferred to be here with us today. So he flew in from California yesterday to talk about a subject near and dear to the heart of every college student, the Digital Millennium Copyright Act. Thank you, Marshall.
Thank you, Professor. The purpose of intellectual property laws is to incentivize creativity. To achieve that goal, intellectual property laws provide some exclusivity as a reward for creativity. In order to benefit society, intellectual property laws must be administered to achieve the goal of incentivizing creativity without imposing an unreasonable restraint on competition and without imposing an unreasonable impediment on research and development. This requires a delicate balance between respect for intellectual property rights on the one hand and encouragement of vigorous competition and encouragement of research and development on the other hand. Today I'll discuss copyrights, trade secrets, the Digital Millennium Copyright Act, free speech and reward for creativity, and the public interest. That's a fair amount to cover, so let's see if we can get started. Let's talk a little bit about the constitutional basis for our copyright statutes. The constitutional basis for our copyright statutes, which is, by the way, is the same basis as the patent statute, is Article 1, Section 8, Clause 8 of the Constitution, which authorizes the Congress to enact legislation to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Note, if you will, that there is a grant of exclusivity. The Constitution specifically provides that it should be for a limited time. The first copyright statute was enacted in 1790, and at that time the state of the art was the printing press. The first copyrightable subject matter was books and periodicals. As the Industrial Revolution progressed in the 1800s, there was a need to update and augment the statute to accommodate new technologies. And so the statute was amended in 1906. Mark Twain gave testimony before the congressional committee that took testimony, which led up to the 1906 statute. As the 20th century industrial revolution, the automation industrial revolution progressed, there was a need to accommodate further new technologies, and so another statute went into effect in 1976. Actually, it was a 1976 statute. It went into effect in 1998. As digital technology began to advance at exponential speed, as the millennium began to close, there was a demand by some for augmenting of the statute to accommodate new digital technology. And so the Digital Millennium Copyright Act was enacted in 1998. Let's look at a few of the basics of copyrights, which hopefully will place this in proper perspective. Copyrights protect an original work of authorship that's fixed on a tangible medium, and it's within a copyrightable category. Number one, it has to be original. It doesn't have to be very interesting, could be poorly drafted, could be boring. The level of originality doesn't have to be high, it just has to be original. Number two, it has to be fixed on a tangible medium. Traditionally, copyrights protected graphic material like books and periodicals. As the new technologies began to progress, there was a question whether copyright law protected computer programs. The 1976 statute made it clear that copyrights protect computer programs in object code, even in object code, which is a sequence of zeros and ones, bits. Bits are, as you can see, protectable under the copyright statute. The new statute did not specifically provide that computer programs are copyrightable subject matter. However, the legislative history made it clear that the Congress intended to extend copyright protection to computer programs. So it could be a character that's a bit in a 0 or 1 on a chip that's measured in nanometers. It's still copyrightable subject matter. Number three, it has to be within a category of copyrightable subject matter. That is, the expression of a work is copyrightable, but not the ideas. For example, if three scholars were to write a book about how to repair the copyright system. If you note from the inside of the book, the copyrights are owned by Abelson, Ledeen, and Harry Lewis. So you cannot copy the work. If you copy the work, don't even think about it. That, without authorization of the copyright owners, that's copyright infringement. On the other hand, if you were to lobby and the Congress to change the legislation to implement some of the ideas to repair the copyright system, that's not copyright infringement. That's a mitzvah. So you can see that copyrights are extent.
So this work has actually been placed under a Creative Commons license on the book's website. So anybody can, in fact, copy it without guilt or fear of prosecution.
Okay. But having said that, I will leave that for the record. The camera doesn't show that person, but the person who made the statement is one of the copyright owners. Okay. Let's look at a fact pattern which might place into context the digital technology and protection of encrypted code under trade secret law and the Digital Millennium Copyright Act, the DMCA, that's a mouthful, and then see how those intersect with the issue of First Amendment. Let's look at the fact pattern and we'll see how trade secret law applies, the DMCA applies, and First Amendment issues apply. The fact pattern is based on the use by the motion picture industry of some of its copyrighted works to be distributed on DVDs, a digital versatile disc. In the late 1980s and 1990s, the motion picture industry began to observe that another revenue stream could be the distribution of its copyrighted motion pictures on DVDs. They tried to distribute them, and they ran into some problems. A DVD is a 5-inch disc that's used to store a large amount of data in digital format. A single DVD can contain a full-length motion picture. But unlike motion pictures on video cassettes, motion pictures contained on DVDs may be technologically copied without any perceptible loss of video or audio quality. Now, this aspect of a DVD makes it particularly susceptible to copying, some would say to piracy. So the motion picture industry had a system invented which was intended to prevent the copying of its copyrighted DVDs that it was distributing. The motion picture industry had invented for it a content scrambling system known as CSS. CSS scrambles the data on the disk and then unscrambles it when the disk is played on a compliant DVD player or a computer. Now, for obvious reasons, the motion picture industry wanted to keep the content scrambling system, CSS, a secret. So they applied trade secret law. They implemented a series of restrictive licensing agreements with each of the members, each licensee. Each member was a licensee, received a different master key to incorporate into its equipment and enough technical know-how to permit it to manufacture its DVDs and put on and be played on a compliant device. A question.
Is CSS a type of digital rights management, or is it separate?
Pardon me?
Is CSS a type of DRM, or is it separate? Like, would that fall under digital rights management?
A content scrambling system was a form of encryption, encryption of digital data on a digital. Now, in spite of the efforts of the motion picture industry to keep the CSS, the content scrambling system, a secret, it was decrypted. By all accounts, it was traced back to a teenager in Norway, John Lech Johansen, who in October of 1999 was able to decrypt CSS and began to distribute it on the web. A number of people began to observe it and began to further distribute it in the fall of 1999. Well, the motion picture industry was rather upset that their CSS was now being distributed, and it began to take a life of its own. It began to be referred to as DECSS, D-E-C-S-S. So the motion picture industry decided that they were going to go to court to try to stop the distribution of DECSS, and they were going to rely on